Okay, so you have husband and wife living in England that been there for some time and want to come back home and retire here in Jamaica. So they signed a contract with a contractor to build a house. The contract was signed on October 4th, 2004. So they agreed that they'll build the house for $8.8 million. The contractor start working. Between the signing of the contract and July 2005, the couple paid the contractor $8.3 million. June 2005, the contractor submitted a claim to the couple $1,246,200. The husband come back and I walk with the contractor and I look on the work was going and I say, boy, more fix this, that one change, this one change, this. I have a couple things there more. The contractor change. But the contractor never take no talk. Contractor say alright and just stop work. Couple of try reach out to the contractor and I tell him, say, boy, we will want to finish the house. Make us see how we can finish the house. And the contractor say, no, I'm not interested in finishing no house. And him just left them with the unfinished house. So what the couple do is May 16, 2006, them get a quantity surveyor to come and do an assessment of how much work was done, what's the value of the work, and how much work is to be completed and what's the value of that work. Him get, based on the measurement from the drawing, him get $9,889,515.37 for the estimated cost of the construction, not including the additional work what them do, and then $871,675, the value of the additional work that wasn't shown on the drawing. What the client them do after that is October 6, 2006, them submit a claim for specific performance. My understanding of that type of claim is that it get the other party to perform the contractual agreement that they originally agreed to. So the aim of that claim was to get the contractor to come back on site and finish the work by July 9, 2009. The contractor no answer, no response, not all out time. So what them do is cancel original claim, go to the court to sue him basically to get the money to finish the house. By February 20th, 2012, the client go back to the QS and do another report to see what is the value of the work after 6 years pass. So the 2012 report estimate that the total construction cost will be 18.7 million now, and that the value of work done move up to $12,974,526.74. But during that 6 years, the house get vandalized. 1.1 million and change worth of damage was done to the house during that 6 years. The new estimated cost of completion gone all the way up to 8.1 million and change. June 29, 2012, the client go swear in and give him testimony as to what really go on. It was not until February 27, 2014 court hearing start. So all this time, them still not hear from the contractor. Him totally unresponsive. Hearing start and him not even there to defend himself. Just the client them go in, them put forward the case. Judge look upon the case and I say, I understand everything are going on and acknowledge that you have suffered loss. The client should still take due care to mitigate any further loss, which the client did. Squatters going out the house to live and vandalize the place. The client have to bring somebody now to get out the squatters them and then build a fence around the house to try and mitigate the damages. So the judge see that now and say, alright, my sister, you really genuine about this thing and you want to finish your house. The judge said before him can establish how much money them forget, him need the answer to 4 questions. What percentage of the work was completed at the time of the breach of the contract? What amount of work was left to be done? What's the sum required for the completion? What was the cost to the client to minimize their loss? So the quantity survey report answered 3 of the 4 questions. So the last question was, what was the cost to the claimant to minimize the loss, and that cost was $82,500. I have to pay somebody to get out the squatters and to build a fence around the place. To fly back and forth from foreign for come to Jamaica, for send different documents and get notary public for sign, and FedEx and the quantity surveyor charges. For the first report him pay $93,200 to the quantity surveyor, and for the second report him pay $70,500 to support him in case. The judge looked upon everything, and the judge said, I am satisfied that the report of the quantity surveyor should be accepted and that they are qualified to carry out the analysis of the current status of the project and an appraisal of the work required to bring it to satisfactory level of completion. So the judge ended up award the client at the end of the day $8.6 million plus 3% interest, and for special damages him award $330,085 and also £2,502.78 with 3% interest. So it wasn't until March 13, 2014 before the client got that verdict from the courts. The signing of the contract happened in October 2004, and it wasn't until March 2014, so almost 10 years later, the whole situation just a work out. So almost 10 years later, the people them still not get them house, cause them a wait for all this for sort out. You can find this case on the Supreme Court of Jamaica website. Is case number 2006 HCV 03555. But these are some of the things that happen in construction. I have not spoken to the quantity surveyor that did that report. I have not spoken to the client. I have not spoken to anybody about this, and I'm just using this case just for as a learning exercise for everybody. So as I say, I don't know the details of the case, but based on the fact that they met up a court and the quantity surveyor was called in on the back end, I'm assuming that no quantity surveyor was present at the signing of that contract. If the quantity surveyor was on that project from the start, it wouldn't end up a court, and it wouldn't end up that it's 10 years later before the whole thing I get sorted out. And the cost that was paid to the quantity surveyor after would have possibly be the same cost if you could have spent on the start, maybe a little bit more, but it'd have saved you 10 years and a whole heap of headache if them they just get the QS on board from the start. Why it couldn't take so long if the quantity surveyor was on the start? If the quantity surveyor would have used a standard farmer contract, or any contract of them would have used, it would have include provisions to deal with disputes. So the CIC standard farmer contract that we generally used in Jamaica, that include for litigation, arbitration, whole heap of other types of dispute resolution exercises that are enforceable by the court. So if the quantity surveyor hold an arbitration exercise and come to a conclusion, did not take, aside from that, the amount of money that would be paid out to the contractor would be regulated by the quantity surveyor, because the quantity surveyor would only pay the contractor for completed work. Therefore, the value of the works on site would be equivalent to the value of money paid to him, the contractor. So it wouldn't be a situation where the contractor have extra money for the client would need back to finish the work, because the quantity surveyor would ensure say that not happen. So when he leave the site, you'd have two things. The quantity surveyor would possibly take in retention from the money. The retention amount would be there for help get back another contractor on the work to finish the work. So you have the retention to fall back on, as well as you have the rest of the money where you never pay him for hold back. So that 8.3 where him get out of the 8.8 which was agreed on, that means that the work would have pretty much done or near done. It wouldn't be at the point that it was when him walk off. It just one example of what can happen when you don't have a proper contract in place with all the teeth needed to properly enforce the obligations of each party. And if there is breaches in that obligation, there is ways of dealing with it. That won't take 10 years. And it won't take all the stress and all of the things that may go with that 10 years to get complete. Because by nature, construction is a rough business. It adversarial. It man and man are gonna cause, teeth and tongue are gonna meet. Things are gonna happen. Client are gonna say this, contractor are gonna say that. So you have to put things in place to help secure your interests, so that things like this don't happen to you. Where 10 years pass and you're still not in a house, you're not in money, and you're out of this thing, you're stressed and frustrated that try to get this thing done and can't get it done. Yes, I just wanted to share this court case. Like I say, you can find more details about it on the Supreme Court of Jamaica website. Thanks for listening.